Before we begin, a quick and important disclaimer. The information presented in this video is for educational and entertainment purposes only. This content does not constitute legal, financial, tax, or investment advice. Laws regarding domestic relations, retirement accounts, and asset division vary significantly by state and are subject to change. The case studies and historical trends discussed are intended to illustrate complex concepts and should not be taken as a predictor of future results. You should always conduct your own due diligence and consult with a qualified professional, such as a family law attorney or a certified financial planner, before making any decisions related to your retirement accounts or legal proceedings. Imagine standing in the heart of Lower Manhattan in the mid-1980s. The air is thick with the ambition of the burgeoning financial sector, and for the first time in American history, the path to wealth is shifting from a gold watch and a guaranteed pension to a mysterious new vehicle known as the 401k. Now fast forward 20 years. That same professional, who spent decades contributing to their account in one of the most expensive urban centers in the world, walks into a mahogany row law firm. They are told that despite every hour of overtime and every dollar of deferred compensation they personally sacrificed, they might lose 50% of that balance overnight. In the high-stakes environment of early U.S. urban centers like New York City, Chicago, and San Francisco, the 401k wasn't just a retirement tool. It became the single most volatile explosive in the American divorce court. We are talking about the era where the pension died and the defined contribution plan was born, creating a legal vacuum that left thousands of professionals destitute, while others walked away with fortunes they didn't earn. This is the story of how the 401k became the ultimate weapon in urban divorce, and if you live in a major city today, the precedents set during this chaotic period are currently dictating exactly what happens to your money. This deep dive solves the one problem that keeps every high-earning American awake at night: how to navigate the complex, often predatory intersection of retirement savings and matrimonial law. Today, we are pulling back the curtain on the historical trends and case studies that define the modern landscape of asset division. You will learn the specific mechanics of the Qualified Domestic Relations Order, or QDRO, the hidden tax traps that can liquidate an account before you even touch it, and the strategic errors made by early urban professionals that you must avoid to protect your financial legacy. This is not just a history lesson. It is a masterclass in financial self-defense for the modern era. To understand the crisis of the 401k and divorce, we have to look at the urban environment of the late 1970s and early 1980s. Before this time, the corporate man in a city like Chicago or Philadelphia relied on a defined benefit pension. These were straightforward. You worked 30 years, and the company sent you a check every month until you passed away. When a divorce happened, the courts struggled to value these future payments. But the pot of money didn't really exist yet. Then came the Revenue Act of 1978, specifically Section 401k. Originally an obscure provision intended to limit certain types of deferred compensation, it was leveraged by benefits consultants to create the retirement system we know today. In major U.S. urban centers, the adoption was rapid. Corporations in high-density business districts realized they could shift the risk of retirement from the company balance sheet to the employee. For the young, upwardly mobile yuppie in a 1980s urban hub, the 401k was sold as a badge of independence. You weren't a cog in the machine, you were an investor. However, the legal system was completely unprepared for what happened when these investors decided to end their marriages. By the mid-1980s, the first generation of significant 401k balances began appearing in urban divorce filings. Unlike a house, which has a clear market value, or a savings account, which is liquid, the 401k was a hybrid asset. It was marital property because it was earned during the marriage, but it was also a tax-deferred vehicle governed by federal law, specifically the Employee Retirement Income Security Act of 1974, or ERISA. This created a jurisdictional nightmare. State courts handle divorce, but federal law governs 401ks. If a state judge ordered a 401k to be split, the plan administrator at the corporation could simply say no, because federal law prevented the assignment of benefits. This tension led to the Retirement Equity Act of 1984. This is a pivotal moment in our historical trend analysis. The REA introduced the Qualified Domestic Relations Order. This was the key that allowed state courts to bypass federal anti-alienation rules. But in the early days of urban centers, no one knew how to write them. Lawyers in cities like Boston or DC were essentially drafting these documents on napkins, leading to catastrophic errors. Consider the case study of a senior analyst at a major firm in the Chicago Loop in 1989. After 12 years of marriage, the couple filed for divorce. The 401k was the primary asset, valued at $400,000, a massive sum at the time. The divorce decree stated the wife was to receive half of the retirement account. However, because they failed to file a proper QDRO that met the specific technical requirements of the plan administrator, the transfer was processed as a standard withdrawal. The result? The husband was hit with a 10% early withdrawal penalty and a 33% combined federal and state tax bill. By the time the dust settled, nearly half of the half she was supposed to receive had vanished into the coffers of the IRS. This wasn't just a mistake. It was a systemic failure of the early urban legal infrastructure. Urban centers exacerbated these issues because of the high net worth concentration. In a rural setting, a divorce might involve a farm and some equipment. In a city like San Francisco during the early tech boom, it involved complex vesting schedules, employer matching, and aggressive stock options within the 401k structure. The math became exponentially more difficult. For example, how do you calculate the separate property portion of a 401k if the employee started the account 3 years before the wedding in a high-growth market? In the 1990s, urban courts began utilizing the coverture fraction, or the Majoska's formula. This formula, which we will break down in extreme detail later, essentially creates a ratio: the length of time the employee was in the plan during the marriage divided by the total length of time the employee was in the plan. In a city like New York, where career longevity at a single firm was once common, this formula could decide the fate of millions of dollars. But even this formula struggled with the volatility of urban markets. If the 401k was invested heavily in dot-com stocks in 1998 and the divorce was finalized in 2001, who bears the loss of the market crash? These are the questions that early urban centers had to answer through brutal, expensive litigation. Furthermore, we must look at the matching contribution trap. In urban corporate cultures, aggressive 401k matching was a primary recruitment tool. But those matches often came with vesting schedules. If a spouse in a Seattle-based tech firm had a 401k where the employer match didn't vest for 5 years, but the divorce happened in year 4, was that unvested money marital property? Early case law in these urban hubs was divided. Some judges argued it was a mere expectancy, like an inheritance, and couldn't be divided. Others argued it was deferred compensation for work performed during the marriage and must be valued. As we move through this masterclass, keep in mind that the 401k divorce is not just about a bank balance. It is about the intersection of federal tax code, state domestic relations law, and the unique economic pressures of American city life. The lessons learned in the skyscrapers of the 80s and 90s are the only reason we have the protections we do today. But as you will see in the coming sections, the complexity has only increased. We are going to look at the shadow assets that urban professionals often try to hide, the loan trap where one spouse drains the 401k through internal loans before the filing, and the step-by-step process of auditing a 401k statement to ensure that every cent is accounted for. This is part 1 of your journey into the most complex financial battlefield in the United States. Prepare yourself, because the data we are about to uncover will change the way you look at your paycheck forever. To understand the true gravity of the 401k in an urban divorce, we have to look past the spreadsheets and into the administrative trenches where these battles were actually won and lost. In the early 1990s, the Qualified Domestic Relations Order, QDRO, was essentially a new language that neither the courts nor the corporate human resources departments spoke fluently. We are looking at a period where a single typo in a legal document could result in a decade-long litigation process or the total forfeiture of tax protections. This was particularly devastating in high-cost urban centers like Philadelphia or Boston, where the 401k often represented the only significant liquid asset other than the family home. Imagine a professional named Michael in 1993 Philadelphia. Michael has spent 15 years climbing the ladder at a major telecommunications firm. His 401k balance is substantial, but more importantly, it is composed of various layers. His own premarital contributions, his contributions during the marriage, the employer match, and the accrued interest on all those components. When Michael and his spouse decide to divorce, the court orders an equal split of the marital portion of the account. This sounds simple on paper, but in the early 90s, the technology to track these distinct layers with precision simply did not exist for most plan administrators. Michael's case highlights a massive historical trend: the administrative lag. When his attorney drafted the first version of the QDRO, it was sent to the plan administrator at the telecom firm. In a modern 2026 context, This would be an electronic submission with immediate feedback. In 1993, this was a physical paper trail. The plan administrator rejected the order because it failed to specify the exact dollar amount versus a percentage, or perhaps it didn't account for the specific plan rules regarding the timing of the payout. While the lawyers argued over the language, the stock market shifted. Because the account wasn't frozen during the drafting phase, the value of the 401k fluctuated wildly. This created a moving target that the legal system was not equipped to hit. This brings us to one of the most critical concepts in urban divorce history: the valuation date. In a city like New York or Chicago, the date the court chooses to value the 401k can be the difference between a comfortable retirement and financial ruin. Historical trends show that urban courts often struggle to decide between three distinct dates. First, the date of separation. Second, the date the divorce action was filed. Third, the date the divorce was actually finalized. In the high-volatility environments of the 90s and early 2000s, these dates could be years apart. Imagine if you were Sarah, a marketing executive in San Francisco during the peak of the dot-com boom in 1999. Your 401k is heavily invested in high-growth tech stocks. At the date of filing in November 1999, your account is worth $800,000. However, due to the backlog in the San Francisco court system, your divorce isn't finalized until late 2001. By that time, the dot-com bubble has burst, and that same 401k is now worth $200,000. If the court uses the 1999 valuation date but orders you to pay your ex-spouse $400,000, you are now in a position of negative equity. You literally owe more to your ex-spouse than the entire account is worth. This scenario wasn't a rare occurrence. It was a recurring nightmare for thousands of urban professionals who were caught in the gears of market timing and legal delay. The step-by-step reality of a QDRO in this era was a gauntlet of 4 specific hurdles. First was the drafting stage, where an attorney had to navigate the incredibly specific requirements of federal law under ERISA. Second was the court's approval, which required a judge to sign off on a document that was often more complex than the rest of the divorce decree combined. Third was the plan administrator's review. This was the most dangerous phase. The plan administrator acted as a third-party gatekeeper. If the QDRO didn't follow the plan's internal logic to the letter, they would reject it, sending the couple back to square one. Finally, there was the implementation phase where the funds were actually moved. In early urban centers, the implementation phase often revealed the hidden tax traps we discussed in Part 1. If the recipient spouse, known as the alternate payee, didn't immediately roll those funds into their own IRA or 401k, the distribution was often treated as a taxable event. We saw case studies where individuals in high-tax states like California or New York were hit with combined tax rates exceeding 40%, because they didn't understand that a QDRO transfer is not a tax-free windfall unless it is handled as a direct trustee-to-trustee transfer. Another historical trend that emerged in these urban hubs was the battle over commingled funds. In a high-density professional environment, many people enter a marriage already having a 401k from a previous employer. They then continue to contribute to that same account throughout the marriage. Over 20 years, the premarital money and the marital money become so intertwined through dividends, interest, and market gains that they are essentially inseparable. Urban courts had to develop complex accounting methods to tease these apart. The most common was the subtraction method, which took the value at the end of the marriage and subtracted the value at the start. But this was flawed because it didn't account for the market growth on the original premarital amount. To solve this, specialized financial experts called forensic accountants became a staple of the urban divorce scene. These professionals would spend weeks reconstructing account histories from paper statements to determine exactly how much of a 401k's growth was passive, meaning it came from market movement, versus active, meaning it came from new contributions. In 2026, we have software that does this in seconds, but in the early days, this was a manual high-stakes investigation that could cost tens of thousands of dollars in expert fees alone. Step by step, the process of dividing a 401k in an urban center began to shape the very nature of American matrimonial law. It forced judges to become pseudo-financial analysts and forced attorneys to become experts in federal tax code. It also highlighted the massive disparity between those who could afford top-tier financial advice and those who couldn't. For a middle-class worker in a city like Detroit or Baltimore, a mistake in the 401k division often went unnoticed until they reached age 65 and realized their expected nest egg was missing a significant portion of its value due to decades-old administrative errors. The complexity didn't stop at the math. It extended to the very psychology of the urban professional. In cities where the cost of living was skyrocketing, the 401k was often seen as the last line of defense against an uncertain future. This led to increasingly aggressive tactics to shield these accounts before a divorce was even on the horizon. We are talking about historical trends of account manipulation that were pioneered in the financial districts of the US and eventually trickled down to the rest of the country. As we continue this masterclass, we have to look at what happened when people realized the legal system was catching up to them. If you couldn't beat the QDRO, could you drain the account before the QDRO was ever written? In the next part, we are going to dive into the dark side of retirement asset division, the secret loans, the hardship withdrawal scams, and the specific maneuvers used by high-earning urbanites to make their 401k balances disappear right before they stepped into the courtroom. You will see how the 401k loan, designed to help workers buy homes or pay for emergencies, became the most effective way to sabotage a spouse's financial future. And we will explore the case study of a New York trader who thought he had found the perfect loophole, only to have it backfire in a way that changed the law forever. We are only just beginning to see how deep this rabbit hole goes. To understand how the 401k loan became the preferred tactical weapon of the 1990s urban divorce, you first have to understand the specific mechanics of Internal Revenue Code Section 72P. This section governs how a participant can borrow from their own retirement account without it being classified as a taxable distribution. In the high-pressure financial districts of cities like New York, Chicago, and Charlotte, savvy professionals realized that while they couldn't simply withdraw their money without massive penalties, they could borrow up to 50% of their vested balance, or a maximum of $50,000. In the mid-90s, $50,000 in a city like Boston could be the difference between keeping a primary residence or being forced into the rental market. Let us look at the case study of a high-level executive we will call James, working in Midtown Manhattan in 1996. James was facing a highly contentious divorce. His 401k, the primary marital asset aside from a Central Park West apartment, was valued at $300,000. James knew that under New York's equitable distribution laws, his spouse was likely entitled to half of that balance. However, James also knew that the law generally looked at the net value of the account at the time of the trial or the date of filing. In a move that became a common historical trend among urban elites, James took out the maximum allowable loan of $50,000 just weeks before the divorce papers were served. In James's mind, he had executed a brilliant maneuver. By taking the loan, he had reduced the net balance of the 401k to $250,000. He then took that $50,000 in cash and utilized it for what he claimed were legitimate living expenses and legal fees, effectively moving $50,000 of marital property into his own pocket before the court could freeze the assets. When the case reached the courtroom, James argued that the court should only divide the remaining $250,000. This is what historical legal analysts call the vanishing balance strategy. However, this is where the loophole began to backfire. Urban judges, particularly in the sophisticated matrimonial parts of New York and California, were becoming increasingly wise to these tactics. The court looked at the timing of the loan and the lack of a clear, non-marital necessity for the funds. The judge ruled that this was a classic case of the dissipation of marital assets. Instead of dividing the $250,000, the court used a legal fiction called a notional balance. They acted as if the $50,000 was still in the account. James was ordered to pay his spouse $75,000, half of the original $300,000, leaving him with only $125,000 in the account and a $50,000 debt he still had to pay back to himself with interest. This brings us to a critical step-by-step breakdown of how these loans actually function during a divorce. Step 1 is the realization of the debt obligation. A 401k loan is not like a bank loan. You are borrowing from yourself. If you are ordered to give half of your account to an ex-spouse through a qualified domestic relations order, the plan administrator usually calculates that half based on the total balance including the outstanding loan. If the account is worth $100,000 but has a $20,000 loan, the total value is $100,000. If the ex-spouse is awarded 50%, they get $50,000. This leaves the account holder with only $30,000 in actual assets and a $20,000 debt. Step 2 involves the hidden interest trap. To keep the loan in good standing, the participant must pay interest back into the account. In early urban centers, many professionals didn't realize that they were essentially paying interest on money that now belonged to their ex-spouse. If the ex-spouse was awarded half of the account, Half of every interest payment James made into that account was effectively a gift to his ex. This created a secondary layer of financial erosion that often lasted for 5 years, the standard term for a 401k loan. Beyond loans, we must examine the hardship withdrawal scam, a darker historical trend that plagued urban divorce courts in the early 2000s. Under the law, a participant can take an early withdrawal from their 401k for an immediate and heavy financial need, such as preventing eviction or paying for medical expenses. In the anonymous, fast-paced environment of a city like Los Angeles, some individuals would falsify or exaggerate these needs to liquidate their accounts. Imagine if a professional in 2002 fabricated a notice of eviction to satisfy their plan administrator's requirements for a hardship withdrawal. They would take a $50,000 distribution, pay the 10% penalty and the income tax, and hide the remaining $30,000 in cash or offshore accounts. By the time the divorce reached the discovery phase, the 401k was empty. This led to the widespread adoption of automatic temporary restraining orders, or ATROs. In many modern urban jurisdictions, the moment a divorce is filed, an automatic injunction goes into effect that legally forbids either spouse from taking a loan, a withdrawal, or changing the beneficiary of a retirement account. But even with ATROs, the ingenuity of the urban professional knows no bounds. We saw the rise of the rebalance sabotage. This is a subtle, high-stakes maneuver where the spouse in control of the 401k, realizing they are about to lose half of it, moves the entire portfolio into high-risk speculative assets. Think of the aggressive tech stocks of 1999 or the volatile real estate investment trusts of 2007. If the market goes up, they keep their half of a larger pie. If the market crashes, they have effectively burned down the house while they were still inside, ensuring that their spouse receives half of nothing. The step-by-step defense against this in early urban centers was the appointment of a receiver or a court order to move the funds into a stable value fund or a money market account during the pendency of the divorce. This was a radical departure from the hands-off approach courts had previously taken. It marked the moment when the 401k moved from being a private investment account to a quasi-public trust that the state felt empowered to manage. As we look at the historical trends of the early 2000s, we also see the emergence of the employer match clawback. Many urban firms used vesting schedules to keep employees loyal. If a professional was 50% vested in their employer's contributions, and a divorce happened, how do you value the other 50% that might vest in 2 years? Some urban courts began using what is known as a reserved jurisdiction, where the court literally stays involved for years after the divorce is final. They would wait until the money vested and then trigger a second QDRO to distribute the newly available funds. This turned a one-time legal event into a multi-year administrative saga. To protect yourself in a 2026 context, you must understand that every click in your 401k portal leaves a digital forensic trail. The tactics used by James in 1996 would be flagged by modern AI-driven auditing software in seconds. But the underlying principles remain. The 401k is not just a bucket of money. It is a complex legal entity with its own rules, its own debts, and its own enemies. We have covered the loans, the hardships, and the sabotage. But there is a much bigger threat lurking in the shadows of the urban financial landscape. It's not about how much is in the account, but who is allowed to keep it. In the next part, we are going to dive into the most controversial aspect of the 401k divorce, the prenuptial and postnuptial conflict. You will learn why a standard prenup is often completely useless when it comes to a 401k, and the one federal law that can override even the most ironclad marriage contract. We will look at a case study where a spouse signed away their right to a 401k, only for the Supreme Court to hand it back to them years later. You won't believe the legal technicality that is currently putting thousands of urban prenups at risk. To understand why a prenuptial agreement, no matter how carefully drafted by a high-priced attorney in a city like Dallas or Los Angeles, often fails to protect a 401k, we must look at the hierarchy of American law. Most urban professionals assume that a contract is a contract. They believe that if two consenting adults sign a document before a notary in 2026, stating that their respective retirement accounts will remain separate property, the matter is settled. However, in the world of 401ks, federal law doesn't just influence the outcome. It completely overrides state-level contracts. This is due to the Employee Retirement Income Security Act of 1974, known as ERISA, and specifically the modifications made by the Retirement Equity Act of 1984. Imagine a character named Alexander, a software architect in Seattle. In early 2026, Alexander is preparing to marry. He has worked at various tech giants for 15 years and has managed to amass a 401k balance of $1.2 million. To protect this legacy, he and his fiancée sign a comprehensive prenuptial agreement. The document explicitly states that Alexander's 401k is his sole and separate property, and that his future spouse waives any and all rights to that account in the event of a divorce or his death. They have a beautiful wedding in the San Juan Islands and return to their urban life. 3 years later, the marriage dissolves. Alexander walks into court confident that his $1.2 million, plus the growth, is safe. But his spouse's attorney raises a single, devastating legal point. Under ERISA, a fiancé cannot waive spousal rights to a 401k. Federal law dictates that only a spouse can waive these rights. Because the prenuptial agreement was signed before the wedding, the person signing it was not yet a spouse. Therefore, according to historical trends in federal case law, that waiver is often considered legally void regarding ERISA-governed plans. This leads to a step-by-step breakdown of the ERISA trap that has decimated the financial plans of thousands of urban elites. Step 1 is the timing of the waiver. Federal law requires that for a spouse to waive their right to be the beneficiary of a 401k, or their right to a portion of it in a divorce, they must do so while they hold the legal status of a spouse. Step 2 is the specificity of the waiver. It cannot be a general statement in a prenup. It must usually be a specific form provided by the 401k plan administrator. Step 3 is the witnessing requirement. ERISA mandates that a spousal waiver must be witnessed by a plan representative or a notary public. Most urban professionals complete Step 1, the prenup, but completely neglect the mandatory post-wedding step of signing the actual 401k plan's waiver forms. Historical trends show that this technicality was the basis for the landmark Supreme Court case, Kennedy versus Plan Administrator for DuPont Savings and Investment Plan. In that case, the court ruled that the plan administrator must follow the plan documents in federal law, regardless of what a divorce decree or a private contract might say. If the plan says the spouse is the beneficiary, and no federal compliant waiver was filed after the marriage began, the spouse gets the money. In an urban environment where the 401k is often the largest asset, this legal loophole creates a massive redistribution of wealth that many find shocking. But the complexity deepens when we compare the 401k to the individual retirement account, or IRA. This is a distinction that frequently causes chaos in urban divorce courts. Unlike a 401k, an IRA is generally not governed by ERISA. It is governed by state contract law. This means that Alexander's prenup would likely protect his IRA, but it is a paperweight when it comes to his 401k. We have seen case studies where professionals in high-rise condos in Miami or Houston lose half their 401k while keeping their entire IRA, all because of the different federal and state statutes governing these two buckets of money. Imagine if Alexander had been told by his lawyer to roll his 401k into an IRA the day after the wedding. By moving the assets from an ERISA-governed plan to a state-governed IRA, he might have been able to bring those assets under the protection of his prenuptial agreement. However, historical trends suggest that many urban professionals keep their money in their corporate 401k plans because of the lower fees and institutional investment options, unknowingly leaving themselves exposed to the ERISA waiver rule. Furthermore, we must address the concept of active versus passive appreciation in these urban centers. Even if a 401k is deemed separate property, any growth that occurs during the marriage can be subject to division. In a high-growth market, this is a critical distinction. Let's say Alexander's $1.2 million account grows to $1.8 million during the 3-year marriage. In many urban jurisdictions, the $600,000 increase is examined under a microscope. Was that growth passive, meaning it resulted purely from market fluctuations? Or was it active, meaning it resulted from new contributions made with marital income, or from Alexander's active management of the portfolio? In cities like San Francisco or New York, where professionals are highly engaged with their portfolios, courts often trend toward labeling a portion of that growth as marital property. This requires a step-by-step forensic analysis. The expert must look at every trade made within the 401k during the marriage. If Alexander moved money from a bond fund to a high-risk tech fund during the marriage, a judge might rule that this active management converted the growth into a marital asset. The burden of proof is often on the account holder to prove that the growth was entirely passive. This is where the urban postnuptial agreement comes into play. As professionals become aware of the ERISA trap, many are attempting to fix their prenups by signing a postnuptial agreement after the wedding. This involves the spouse signing the specific 401k waiver forms required by the employer. However, this creates its own set of risks. In the high-pressure social environments of major U.S. cities, postnuptial agreements are often challenged on the grounds of duress or coercion. A spouse might argue, "I only signed that 401k waiver because my partner threatened to leave me if I didn't." In the 2026 legal landscape, the standards for a valid postnup are incredibly high, requiring full financial disclosure and independent legal counsel for both parties. Step by step, the 401k becomes a tether that keeps divorced couples bound together for years. If a post-wedding waiver isn't signed perfectly, and a QDRO is required, the parties are forced to interact with each other's HR departments and plan administrators, often for months or years after the divorce is finalized. We have seen historical trends where a simple failure to sign a one-page document in a corporate office in 1995 led to a 2026 legal battle over millions of dollars in compounded interest. The lesson for the modern American is that the 401k is a federal creature. It lives in a world where your private agreements are often secondary to the rules written by Congress and interpreted by the Supreme Court. The urban professional who thinks they are protected by a standard prenup is often standing on a foundation of sand. But what happens when the 401k isn't just a single account? What happens when a high-earning urbanite has multiple legacy accounts from 4 different employers, all with different plan rules and different ERISA interpretations? As we move forward, we are going to look at the logistical nightmare of the multiple account divorce. You will see how the process of tracking down old 401ks in a city like Atlanta or Denver becomes a game of financial hide-and-seek. We will explore the case study of a woman who discovered her ex-husband had 3 secret 401ks 10 years after their divorce was final, and the legal mechanism she used to claw back her share. We are moving from the law of the contract to the law of the hunt. In the next part, we dive into the world of forensic 401k discovery and the hidden paper trails that even the most careful professionals leave behind. The hunt for retirement assets in a sprawling urban landscape like Atlanta, Denver, or the Silicon Valley tech corridor is rarely a straight line. It is a forensic odyssey that requires the precision of a surgeon and the persistence of a private investigator. In the early stages of a U.S. urban divorce in 2026, the primary challenge isn't just dividing the assets you see on the table. It is finding the assets that have been left behind in the wreckage of a 20-year career. Urban professionals are defined by their mobility. Unlike the previous generation that stayed with one manufacturing firm in the Midwest for 4 decades, the modern urbanite often changes employers every 3 to 5 years. Each move creates a potential orphan 401k, a legacy account that sits in a forgotten corner of a massive financial institution, quietly compounding and often completely absent from the current marital balance sheet. Imagine a character named Marcus, a senior software consultant living in the high-altitude tech hub of Denver in 2026. Marcus is in the middle of a divorce from his spouse, Elena. During the discovery phase, Marcus provides his current 401k statement from his employer of the last 4 years. The balance is significant, perhaps $300,000. To the untrained eye, this is the asset to be divided. But Elena's legal team understands the historical trends of the Denver tech scene. They know that between 2012 and 2022, Marcus worked for 3 different startups and 2 major telecommunications firms. They begin the forensic step-by-step process of the 401k hunt. The first step in this masterclass of discovery is the W-2 audit. In a major U.S. city, the tax return is the ultimate map of a person's financial history. Elena's team requests every W-2 from the last 10 years of the marriage. They are looking specifically at Box 12, Code D. This is the smoking gun. Code D indicates elective deferrals to a 401k plan. By tracking every year Marcus had a Code D entry, they can map out which employers offered a plan and, more importantly, how much Marcus was contributing. If there is a Code D entry for a job Marcus held in 2016, but no corresponding 401k account is listed in his current financial disclosure, a legacy account exists somewhere in the ether. The second step involves the use of the Social Security Administration. Many urban professionals are unaware that when an employee leaves a company but leaves behind a vested balance in a 401k, the plan administrator is required to report that information to the IRS, which then shares it with the SSA. In 2026, a spouse can request or subpoena a notice of potential benefit rights. This document is a federal ledger of every retirement plan where the individual has a vested interest that has not yet been paid out. For Marcus, this notice reveals a $40,000 account from a startup that went defunct in 2019. The company is gone, but the 401k plan, managed by a third-party administrator, still exists. This brings us to the logistical nightmare of the third-party administrator, or TPA. In the fragmented corporate world of early U.S. urban centers, companies often outsource their retirement plan management to massive firms like Fidelity, Vanguard, or Alight. When a company goes bankrupt or is acquired, a frequent occurrence in cities like Austin or Seattle, the 401k assets don't disappear. They are moved to a successor plan or a terminal trust. The hunt then requires subpoenaing the TPA. Elena's team must track down the successor entity of Marcus's 2019 startup. This involves searching the Department of Labor's Form 5500 database. Every 401k plan in the U.S. with more than 100 participants must file a Form 5500 annually. This public record contains the name of the plan administrator, the number of participants, and the total value of the plan's assets. By cross-referencing these filings, the forensic team can identify exactly where Marcus's money was transferred. But what happens when the omission of an account isn't an accident? This is where we examine the historical trends of intentional asset concealment. In high-stakes urban environments, some individuals use the complexity of the 401k system to engage in what is known as account layering. A professional might take a distribution from an old 401k and instead of rolling it into a visible IRA, they might roll it into a new 401k at a subsequent employer, effectively burying the old money inside a new larger balance. This is done to obscure the separate property portion of the account. If Marcus can't prove which portion of his current $300,000 balance came from his premarital years, the court might assume the entire balance is marital property. Conversely, if Elena can't find the rollover trail, she might miss out on the growth that occurred on marital funds that were moved into a separate property bucket. The step-by-step countermove to this is the account reconstruction. A forensic accountant takes the starting balance of every account and reconciles every single contribution, withdrawal, and rollover. They are looking for the flow of funds. In a 2026 Denver court, if Marcus is found to have intentionally hidden an account or provided misleading information about a rollover, he faces the potential outcome of the omitted asset penalty. In many jurisdictions, including California and parts of the East Coast, if a spouse intentionally conceals an asset during a divorce, the judge has the statutory authority to award 100% of that asset to the other spouse as a punitive measure. This is the ultimate deterrent in the urban divorce hunt. Furthermore, we must consider the case study of the self-directed 401k. This is a favorite tool of the urban entrepreneur and the high-end real estate investor. Unlike a standard 401k where you choose from a list of mutual funds, a self-directed 401k allows the participant to invest in non-traditional assets like private equity, gold, or even urban rental properties. Finding these assets is exponentially more difficult. The paper trail doesn't lead to a major brokerage firm. It leads to private contracts, LLC operating agreements, and physical titles. If Marcus had used a self-directed 401k to buy a small interest in a Denver warehouse, Elena's team would have to look past the 401k statement and into the underlying investments. They would have to value the private equity itself, which requires a whole different set of experts. In the fast-paced, high-retention world of urban litigation, the 401k hunt is the foundation of the final settlement. You cannot divide what you have not discovered. Step by step, the forensic team builds a comprehensive matrix of every dollar ever deferred, every match ever vested, and every rollover ever executed. They are turning the chaos of a modern multi-employer career into a clean, bifurcated ledger. But discovery is only the beginning of the battle. Once the accounts are found and the values are established, you enter the most dangerous phase of the entire process: the actual transfer of the money. This is where the IRS is waiting. In the next part of this masterclass, we are going to dive into the tax bomb of 401k liquidation. You will learn the difference between a direct rollover and a manual distribution, and why a single check made out to the wrong name can trigger a tax bill that destroys 40% of your settlement in 48 hours. We will explore the case study of a woman in Chicago who won her divorce but ended up in debt to the government because of a clerical error at her bank. The hunt is over, but the explosion is just beginning. We are moving from the forensic lab to the tax office, and you cannot afford to miss the specific mechanics of the transfer that we are about to reveal. The moment the judge signs the final divorce decree in a high-rise courtroom in Chicago or Los Angeles, a silent countdown begins. You have successfully navigated the forensic hunt, you have identified the legacy accounts, and you have a court-ordered right to your share of the 401k. But now you face the most dangerous financial entity in the United States, the Internal Revenue Service. In the world of urban asset division, the transition from a court order to a funded account is a minefield of mandatory withholdings, tax brackets, and administrative traps that can incinerate a settlement faster than a market crash. To understand the scale of this risk, we must look at the mandatory 20% federal withholding rule, a historical trend in the tax code that was designed to ensure the government gets its cut before you ever see a dime. Imagine a character named Linda, a senior healthcare administrator in Chicago in 2026. After a grueling 18-month divorce, the court awards Linda $500,000 from her ex-spouse's 401k. This is a life-changing sum of money. Linda's attorney tells her the QDRO is approved, and the funds are ready for distribution. Linda, facing the astronomical cost of relocating to a new condo in the Gold Coast, decides she wants the cash in her hand. She instructs the plan administrator to send her a check. This is the exact moment the tax bomb detonates. Under federal law, specifically the Internal Revenue Code governing qualified plans, any distribution made directly to a participant or an alternate payee is subject to an immediate, mandatory 20% federal income tax withholding. For Linda, the plan administrator automatically deducts $100,000 from her $500,000 settlement and sends it directly to the IRS. Linda receives a check for $400,000. But the nightmare is only beginning. That 20% is merely a down payment. Because Linda lives in Illinois, a state with its own income tax requirements, and because her $500,000 distribution is added to her already high salary as a healthcare administrator, she is pushed into the highest federal tax bracket for 2026. By the time she files her taxes next April, she may owe an additional 15 to 20% in combined federal and state taxes. Her $500,000 settlement has effectively been reduced to less than $300,000 of actual purchasing power. This brings us to a critical step-by-step masterclass on the direct trustee-to-trustee transfer versus the 60-day rollover. Step 1 is understanding that you should almost never touch the money. In the early U.S. urban centers, many individuals made the catastrophic mistake of receiving a check made out to them personally, thinking they had 60 days to deposit it into a new IRA to avoid taxes. This is known as an indirect rollover. The problem is the mandatory withholding. If Linda received a check for $400,000 because of the 20% withholding, she still has to deposit the full $500,000 into her new IRA within 60 days to avoid all taxes and penalties. This means she would have to find $100,000 of her own cash to make up for the amount the IRS already took. If she cannot find that cash, the $100,000 taken by the IRS is treated as a permanent distribution, subject to full income tax. The only safe path, and the one we see in successful case studies of urban professionals, is the direct transfer. In this scenario, the money moves from the ex-spouse's 401k directly to Linda's newly established IRA without her ever touching it. The check is made out to the financial institution for the benefit of Linda. This bypasses the 20% withholding entirely and preserves the tax-deferred status of every single dollar. In 2026, with the complexity of digital banking, ensuring that the account numbers and the specific wording of the payee line are perfect is a high-stakes administrative task. A single clerical error, like a bank teller accidentally depositing the check into a standard savings account instead of a qualified IRA, can trigger the same tax catastrophe. However, there is a specific historical trend in 401k law that offers a unique strategic advantage for those in an urban divorce, known as the QDRO exception to the 10% penalty. Usually, if you withdraw money from a 401k before age 59 and a half, you pay income tax plus a 10% early withdrawal penalty. But under Internal Revenue Code Section 72T(2)(c), payments made to an alternate payee under a QDRO are exempt from that 10% penalty. Imagine if Linda in Chicago actually needed $50,000 for a down payment on her condo but wanted to keep the rest tax deferred. She could strategically take a $50,000 cash distribution directly from the QDRO, pay the income tax on it, but avoid the $5,000 penalty she would have otherwise faced. This is one of the few instances where the tax code provides a break for divorced individuals, but it is a one-time opportunity. Once those funds are rolled into Linda's own IRA, they lose their QDRO status. If she pulls money out of the IRA the next day, the 10% penalty applies again. We must also analyze the concept of the net of tax valuation. In the high-end legal circles of cities like New York and San Francisco, Sophisticated attorneys no longer view a dollar in a 401k as equal to a dollar in a bank account. This is a critical historical trend in modern negotiations. If one spouse is keeping the house, which has $500,000 in equity, and the other spouse is keeping $500,000 in a 401k, the spouse with the 401k is actually getting a much worse deal. The house equity can often be accessed tax-free under current U.S. primary residence exclusions, while the 401k is a future tax liability. In 2026, forensic accountants in urban centers perform a tax-affected valuation, where they discount the value of the 401k by the projected future tax rate. They might argue that $500,000 in a 401k is only worth $350,000 in present-day, after-tax value. Failing to account for this during the negotiation phase is how many urban professionals end up with a settlement that looks fair on paper, but is a functional disaster in reality. The complexity of state-specific nuances cannot be overstated. In a city like New York, where city income tax is layered on top of state and federal tax, the erosion of a 401k distribution is even more aggressive. We have seen case studies where individuals in Manhattan effectively lost nearly 50% of their cash distribution to various government agencies. This creates a powerful incentive for the direct rollover, but it also creates a tactical opportunity for the spouse who doesn't want to divide the account. They may offer a smaller amount of immediate cash from a non-retirement source in exchange for keeping the entire 401k. This is the trade-off that defines the urban divorce, the battle between immediate liquidity and long-term growth. But what if everything goes right with the paperwork, the taxes are accounted for, and the QDRO is ready to be implemented, but then the unthinkable happens? What if the person who holds the 401k passes away before the money is actually moved? In the fast-paced, high-stress environments of American urban centers, this is a recurring tragedy that exposes a massive hole in the legal system. In the next part of this masterclass, we are going to explore the dead person trap. You will learn why a divorce decree might be completely unenforceable if one party dies before the plan administrator processes the QDRO, and the specific legal backstops, like the 401k life insurance hedge, that savvy urbanites use to protect their interest. We are moving from tax law to the law of mortality, and the stakes could not be higher. If you think your settlement is safe because the judge signed the paper, you are ignoring the most significant risk of all. The gap between the moment a judge bangs the gavel and the moment the funds actually land in your account is the most perilous time frame in American law. In the high-velocity urban centers of the United States, this period is often referred to as the limbo state. You have a legal right to the money, but you do not yet have the money itself. In a city like New York or Los Angeles, where the court backlogs can extend for months, the risk of a life-altering event occurring during this administrative delay is a statistical reality that has devastated thousands of unsuspecting spouses. This is the law of mortality, and in the world of 401ks, death doesn't just end a marriage. It can effectively delete a court order if the paperwork hasn't reached the right desk. Imagine a character named David, a high-performing architectural lead in Manhattan in the year 2026. After 2 decades of marriage and 3 years of grueling litigation, David and his wife, Sarah, finally reach a settlement. The court awards Sarah $1.2 million from David's 401k. On a Friday afternoon, the judge signs the judgment of divorce. Sarah and her legal team feel a sense of immense relief. They believe the battle is over. However, the Qualified Domestic Relations Order, the QDRO, which is the actual vehicle that tells the 401k plan administrator to move the money, is still being drafted by a specialized paralegal. It hasn't been signed by the judge yet, and it certainly hasn't been served on the plan administrator at David's firm. Over the weekend, David suffers a sudden catastrophic health event and passes away. In the eyes of the state of New York, Sarah and David were divorced the moment the judge signed that decree on Friday. But in the eyes of the federal government and the 401k plan administrator, the situation is governed strictly by the plan documents rule. According to the 401k plan's records on Monday morning, David was an active participant, and his designated beneficiary was still Sarah, not because they were married, but because he never changed the form. This creates a historical trend known as the beneficiary conflict. You might think Sarah is fine because she is still the beneficiary. But what if David had surreptitiously changed his beneficiary to his sibling or a new partner weeks before the divorce was final? Under ERISA, federal law dictates that the plan administrator must pay the person listed on the official beneficiary designation form, regardless of what a state divorce decree says. If David changed the beneficiary to his brother, and the QDRO was not yet in place to lock down Sarah's interest, the plan administrator is legally obligated to cut a check to the brother. Sarah, despite having a signed judgment from a state Supreme Court judge awarding her $1.2 million, could find herself standing at the back of the line in probate court, trying to sue an estate that might already be empty. The step-by-step defense against this mortality trap began in early urban centers with a tactical maneuver called the joinder of the plan. In jurisdictions like California, savvy attorneys realized they couldn't just sue the spouse. They had to legally pull the 401k plan itself into the divorce. By joining the plan as a party to the action, the court gains the authority to issue an immediate injunction against the plan administrator. This effectively freezes the account. It prevents any loans, any withdrawals, and most importantly, any changes to the beneficiary designation while the divorce is pending. For a professional in a 2026 urban setting, failing to join the plan is considered a major procedural oversight that leaves the asset exposed to the whims of the participant. Another critical mechanism that emerged from these high-stakes urban battles is the nunc pro tunc order. This is a Latin term meaning now for then. In cases where a spouse dies after the divorce is granted, but before the QDRO is finalized, attorneys can petition the court to sign the QDRO retroactively, dating it back to the day of the divorce decree. Historical trends in federal appellate courts show a long-standing tension over whether a nunc pro tunc order is sufficient to satisfy ERISA's requirements. Some plan administrators have historically fought these orders, arguing that you cannot create a qualified order for a person who is already deceased. The case studies from the early 2000s in the Second and Ninth Circuits established that as long as the order clarifies a right that was already granted in the divorce decree, it can potentially be recognized. But this requires expensive, high-level federal litigation that most people are not prepared for. To add another layer of complexity, we must look at the survivor annuity trap. Even if the QDRO is processed while everyone is alive, if the drafter fails to specifically check the box that designates the ex-spouse as the surviving spouse for purposes of the plan's annuity, the benefits could vanish upon the participant's death. Imagine if Sarah receives her share of the 401k, but the plan also includes a pension-style monthly payment component. If David dies and the QDRO didn't explicitly name Sarah as the survivor, the plan administrator may stop the payments entirely, regardless of the divorce settlement. This is a nuance of federal law that urban practitioners in cities like Chicago and D.C. have had to master through decades of trial and error. Furthermore, we see the rise of the life insurance hedge in modern 2026 settlements. In high-value urban divorces, the court will often order the participant to maintain a life insurance policy specifically to collateralize the 401k transfer. If Sarah is owed $1.2 million, the court might require David to keep a $1.2 million term life insurance policy in place with Sarah as the beneficiary until the moment the 401k funds are successfully moved into her IRA. This creates a redundant layer of protection. If David passes away during the limbo state, Sarah may lose her claim to the 401k due to federal preemption, but she recovers the same amount through life insurance proceeds. Step by step, the process of securing a 401k in an urban center has evolved into a race against time in biology. The administrative hold is the first line of defense. The joinder of the plan is the second. The life insurance hedge is the third. And the nunc pro tunc order is the emergency parachute. But even with all these protections, there is a psychological toll that these delays take on the urban professional. The constant fear that a clerical error or a sudden accident could erase 20 years of savings creates a pressure cooker environment in the final weeks of a divorce. As we look at these historical trends, we realize that the 401k is not just a financial asset. It is a legal fortress that requires a specific set of keys to enter. If you lose the keys or if the lock is changed before you get there, the results are catastrophic. We have analyzed the taxes, the loans, the discovery, and the mortality risks. But there is one group of people for whom these rules change entirely. We are talking about the individuals who are approaching the finish line of their careers. In the next part of this masterclass, we are going to dive into the world of the gray divorce. You will learn why getting divorced at age 60 in a city like Seattle or Phoenix is fundamentally different than getting divorced at age 30. We will explore the Social Security offset, the catch-up contribution conflict, and the devastating impact of the required minimum distribution on a split account. The rules of the game are about to shift from accumulation to preservation, and the mistakes made at this stage are often irreversible. You will see how the 401k becomes a different beast entirely once the clock starts ticking toward retirement age. The masterclass continues with the intersection of age and asset division, and the data suggests that for the older urban professional, the 401k is the most dangerous asset of all. When we enter the era of the gray divorce in 2026, the 401k ceases to be a simple investment account and becomes a lifeline. In high-cost urban centers like Seattle or Phoenix, where the cost of living remains stubbornly high, the division of retirement assets for those over the age of 55 is not just about math. It is about survival. Historical trends show that the divorce rate for U.S. couples aged 50 and older has more than doubled since the 1990s. This surge, often called the Gray Divorce, creates a unique set of financial pressures because there is no longer a multi-decade horizon to recover from a poorly executed asset split. Imagine a character named Robert, a 63-year-old software engineer in the Seattle tech corridor in 2026. Robert has been married to Diane for 32 years. His 401k is valued at $2.4 million. He is 3 years away from his planned retirement. In a younger divorce, a professional might shrug off a 50% loss of their account, knowing they have 30 years of contributions ahead. For Robert, losing $1.2 million today means his entire retirement plan is effectively decapitated. He cannot work 30 more years to make it up. One of the most complex step-by-step hurdles in this urban gray divorce is the Social Security offset and its interaction with the 401k. Many people are unaware of the 10-year rule. Under U.S. federal law, if a marriage lasted 10 years or longer, a divorced spouse is entitled to claim Social Security benefits based on the other spouse's earnings record, provided they remain unmarried and are at least 62 years old. In the Seattle case study, Diane has spent most of the marriage managing the household and has a minimal Social Security record. She can claim 50% of Robert's full retirement age benefit without reducing Robert's own check by a single cent. This creates a high-stakes negotiation point in urban centers. In 2026, sophisticated attorneys use this Social Security windfall to offset the division of the 401k. They might argue that since Diane will receive a significant monthly stream of income from Robert's Social Security record, effectively a federal subsidy, Robert should be allowed to keep a larger percentage of the 401k to balance the total income of both parties in retirement. This is not a legal requirement, but it is a frequent historical trend in equitable distribution states. Another critical factor is the catch-up contribution conflict. By 2026, the IRS catch-up contribution limits for those over 50 have reached significant levels. Robert has been pumping an extra $7,500 per year into his account for over a decade. In a contentious divorce, the question arises: were these catch-up contributions marital property or a form of separate property intended to secure Robert's individual future? Because these contributions were made with marital income, courts almost universally label them as marital assets. However, the forensic analysis must look at the source of these funds. If Robert used an inheritance to fund his catch-up contributions, that layer of the 401k might be exempt from the QDRO. Then we must confront the required minimum distribution, or RMD, trap. Under the Secure Act 2.0, which is fully operational by 2026, the age for starting RMDs has pushed towards 73 and eventually 75. But if a 401k is split when the participants are 65, who bears the future tax burden of these forced distributions? Step 1 in managing the RMD trap is the bifurcation of the account. Once the QDRO is processed and Diane's $1.2 million is moved into her own IRA, she becomes solely responsible for her own RMDs based on her own life expectancy. However, if the account remains joined during a long, drawn-out legal battle that lasts until they reach RMD age, the tax complications are immense. The IRS doesn't care that you are in the middle of a divorce. If you don't take the RMD, you face a penalty of up to 25% of the amount that should have been distributed. In 2026, we see case studies where urban couples lose tens of thousands of dollars because they were too busy arguing over the asset split to remember the mandatory tax distributions. Furthermore, we must address the IRMA surcharge. This stands for the Income-Related Monthly Adjustment Amount. For urban professionals in high-income brackets, taking a large distribution from a 401k to settle a divorce can spike their reported income for the year. This can lead to a massive increase in Medicare Part B and Part D premiums 2 years later. Imagine Robert in Seattle takes a distribution to pay Diane her share. This pushes his income over the threshold, and suddenly his Medicare premiums double for the next 24 months. This is a hidden cost of the 401k divorce that young couples never have to consider, but for the gray divorce, it is a primary concern. We also have to analyze the sequence of returns risk during the division process. In an urban environment like Phoenix, where many retirees have their entire net worth in the markets, a divorce that coincides with a market downturn is a disaster. If Robert's $2.4 million account drops to $1.8 million during the divorce proceedings, but the legal agreement was based on the $2.4 million figure, he may be legally obligated to give Diane more than half of what is actually left. Step-by-step risk mitigation in 2026 involves using a dynamic valuation clause in the settlement. This ensures that the percentage awarded to the spouse is based on the account's value at the time of transfer, rather than a fixed dollar amount that could become impossible to pay if the market shifts. The gray divorce also highlights the problem of healthcare liquidity. In early U.S. urban centers, the 401k was often used as a backstop for medical emergencies. When the account is split, both parties lose that cushion. In 2026, we see a trend where urban courts are ordering a portion of the 401k to be held in a specialized health savings account, or used to fund a long-term care insurance policy, as part of the divorce decree. This recognizes that for a 65-year-old, the 401k isn't just for vacations. It is for the medical costs that can reach hundreds of thousands of dollars in the final decades of life. Consider the case study of a Phoenix couple who split their 401k equally at age 60. 5 years later, the husband developed a chronic condition requiring specialized urban care. Because his 401k was halved, he lacked the liquidity to pay for the highest tier of treatment without triggering massive tax penalties from early-stage RMDs. This highlights the potential outcomes of the gray divorce. It creates two smaller, more vulnerable financial units instead of one robust one. The complexity of the gray divorce in 2026 is a warning to every urban professional. The tools and laws designed for the 401k were built for accumulation, but they are being tested by the reality of mass-scale elder liquidation. Every decision made in the Seattle Tech Corridor or the Phoenix suburbs today regarding a 401k split will resonate for 20 more years of retirement. But even as we solve the issues of the gray divorce, a new and even more terrifying threat is emerging in the urban financial landscape. It is a concept that most people have never heard of, but it is currently being used to drain 401ks before a spouse even knows a divorce is coming. It is the rise of the artificial intelligence-driven asset shield. In the next part of this masterclass, we are going to dive into the world of digital obfuscation. You will learn how high-frequency trading and automated crypto conversions are being used within self-directed 401ks to make millions of dollars vanish in a single afternoon. We are moving from the law of mortality to the law of the algorithm, and the discovery techniques we discussed in Part 5 are about to become obsolete. You need to know how the most sophisticated urbanites in 2026 are using tech to win the 401k war. The shift from paper ledgers to algorithmic shields represents the most significant evolution in the history of urban asset division. In the early days of U.S. urban centers like New York and San Francisco, a professional looking to hide assets had to rely on physical paper trails, offshore bank accounts, or complex shell companies. But as we move into the landscape of 2026, the battle for the 401k has migrated into the digital ether. We are now witnessing the rise of the artificial intelligence-driven asset shield, a technological maneuver that makes the forensic discovery techniques of the 1990s look like primitive archaeology. In high-stakes tech hubs like Austin, Texas, or the Silicon Valley corridor, the sophisticated urban professional is no longer just an investor. They are a digital architect using high-frequency algorithms to obscure the true value of their retirement legacy before a divorce filing ever reaches the courthouse. Imagine a character named Ethan, a senior systems architect for a major fintech firm in Austin in 2026. Ethan has been married to Maya for 15 years, and their primary marital asset is Ethan's self-directed 401k, valued at roughly $3.5 million. Because Ethan works at the intersection of finance and technology, he has access to a self-directed brokerage account, or SDBA, within his corporate 401k plan. This is a historical trend that accelerated in the early 2020s, where major urban employers began offering employees the ability to move their 401k funds out of standard mutual funds and into a wide-open brokerage window. Ethan, sensing that his marriage is failing, initiates a strategy of digital obfuscation. He doesn't simply withdraw the money, which would trigger the tax bombs we discussed in Part 6. Instead, he implements an AI-driven trading bot within his 401k brokerage window. This bot is programmed to execute thousands of microtrades across highly volatile asset classes, including leveraged ETFs, synthetic real estate tokens, and specialized digital commodity futures that are now legal within certain self-directed retirement frameworks. The potential outcome of this strategy is the creation of a volatility fog. When Maya's legal team requests a 401k statement for the date of filing, they receive a document that is fundamentally obsolete by the time it is printed. Because the AI is shifting the capital across different sectors every millisecond, the account's value fluctuates by hundreds of thousands of dollars in a single trading day. This creates a valuation nightmare for the court. Which snapshot do they use? If the account is worth $3.5 million on Monday morning but, due to intentional algorithmic volatility, it is worth $2.8 million on Monday afternoon, Ethan has effectively vanished $700,000 of marital equity without ever taking a distribution. To understand how to counter this, we must look at the step-by-step masterclass of 2026 forensic discovery. Step 1 is moving beyond the monthly statement. In an urban tech-centered divorce, a monthly summary is a useless piece of paper. Maya's forensic team must subpoena the API logs and the raw transaction metadata from the brokerage firm. This allows them to see the frequency and the logic of the trades. Step 2 involves algorithmic reconstruction. In 2026, you cannot catch a bot with a human accountant. You need a counterbot. Maya's team employs a forensic AI that analyzes Ethan's trading patterns to determine if the volatility was a legitimate investment strategy or a bad faith attempt to dissipate assets. This leads to a critical case study involving a high-frequency trader in Chicago who attempted to use a similar strategy in late 2025. The trader argued that the losses in his 401k were simply the result of market forces and his aggressive investment style. However, the forensic AI identified a divorce mode in his trading algorithm, a specific set of instructions that triggered high-risk trades only after the date of separation. The court ruled this as a breach of fiduciary duty to the marital estate. The historical trend in urban courts is now shifting toward a strict liability standard for AI-managed 401ks. If you turn over your marital assets to an algorithm, you are legally responsible for its output, and the court can impute the lost value back to your side of the ledger. But the tech war doesn't stop at volatility. We are also seeing the rise of the shadow rollover. In the 2026 urban landscape, there are hundreds of boutique fintech platforms that offer micro-retirement accounts. An urban professional might execute a series of tiny, automated rollovers, amounts under $500 that fly under the radar of standard bank alerts, moving money from a major 401k provider like Fidelity or Vanguard into a constellation of obscure digital platforms. Over the course of a year, these micro-rollovers can move six-figure sums into accounts that are not yet integrated into the standard discovery databases used by divorce attorneys. Imagine if Ethan had set up 12 different micro-accounts in the names of various retirement LLCs he controlled. To find this money, Maya's team has to perform a digital exhaust audit. This involves tracking every outbound transfer, no matter how small, and cross-referencing them with Ethan's browser history and app usage logs, which are now frequently subpoenaed in high-value urban divorces. The step-by-step process of tracing this digital breadcrumb trail is the only way to ensure that the 401k balance on the final decree matches the reality of the assets. Furthermore, we must address the 2026 trend of tokenized real estate within the 401k. In cities like New York and Miami, urban professionals are using their self-directed 401ks to buy fractional tokens of luxury high-rises. This complicates the divorce because the market value of a fractional token in a specific building is highly illiquid and difficult to verify. If Ethan buys a 2% token of an Austin skyscraper within his 401k, he can claim that the token has depreciated, while the underlying real estate is actually soaring in value. This requires a double-layer valuation, an audit of the 401k, and a physical appraisal of the real estate asset the 401k actually holds. The lesson for the modern American in 2026 is that the 401k is no longer a set-it-and-forget-it account. In the context of a divorce, it is a dynamic, high-tech battlefield. The winners are those who understand the code behind the capital. If you are entering a divorce in an urban center today, you are not just fighting over money. You are fighting over data. The sophisticated tactics of the asset shield are designed to wear down an opponent through complexity and delay, hoping they will settle for a smaller amount just to end the technological exhaustion. As we approach the end of this deep dive masterclass, we have covered the laws of the 80s, the tax bombs of the 90s, the mortality traps of the 2000s, and the algorithmic wars of 2026. But there is one final piece to the puzzle. How do you actually cross the finish line? How do you move from the chaos of discovery and the fear of tech sabotage to a final, ironclad settlement that actually secures your future. In the final part of this series, we are going to unveil the final settlement matrix. You will learn the specific golden ratio that urban professionals use to trade 401k assets for other marital property, the one clause you must include in your decree to protect against future tax law changes, and the step-by-step checklist to ensure your 401k transfer is truly bulletproof for the next 40 years. We are moving from the battlefield to the victory lap. You have fought for every dollar. Now you need to know how to keep it. In Part 10, we provide the ultimate blueprint for the 401k divorce survivor. Don't let the last 10% of the process undo all the work you've done to get here. To cross the finish line of a 401k division in a major U.S. urban center in 2026, you must transition from a mindset of litigation to a mindset of precise execution. The battle is no longer about who is right. It is about who is efficient. We are entering the final settlement matrix. This is the stage where the theoretical awards granted in a courtroom become the actual dollars that fund your future. In high-stakes environments like Charlotte, North Carolina, or Denver, Colorado, the final 10% of the process is where the most significant wealth leakage occurs. To prevent this, we must analyze the specific historical trends of the asset swap and the implementation of the golden ratio. Imagine a character named Jordan, a senior project manager in the thriving tech and finance hub of Charlotte in 2026. Jordan and his spouse are finalizing their divorce. They have two primary assets of nearly equal face value: a home with $600,000 in equity, and a 401k with $800,000 in the balance. In the early days of urban divorce, a couple might simply trade these one for one. Jordan takes the 401k, the spouse takes the house. On paper, it looks like Jordan is winning by $200,000. But in the 2026 tax landscape, this is a strategic error that could lead to a potential outcome of long-term financial regret. This brings us to step 1 of the final settlement matrix, the tax-affected valuation. Jordan must understand that $401,000 are not the same as home equity dollars. Home equity, under current U.S. tax law, often carries a significant capital gains exclusion for primary residences. The 401k, however, is a deferred tax liability. Every dollar Jordan withdraws in retirement will be taxed as ordinary income at whatever the rates are in 2040 or 2050. In 2026, sophisticated urban professionals use the golden ratio to normalize these assets. They discount the 401k by a projected tax rate, often 20 to 30%, to find its cash equivalent value. If we apply a 25% discount to Jordan's $800,401,000, its real-world value is $600,000. Only then do we have a fair trade for the home equity. Failing to perform this calculation is a historical trend that has left thousands of urban professionals asset-rich, but cash-poor, once the IRS takes its share. Step 2 involves the implementation of the gains and losses clause. This is the most frequently overlooked detail in modern U.S. divorce decrees. Imagine if Jordan's 401k is being split 50-50. The judge signs the order on May 1st, but because of the administrative lag in urban centers, the money doesn't actually move until August 15th. In those 3.5 months, the market could shift by 10 or 15%. If the decree simply states a fixed dollar amount, say for $100,000, the recipient spouse misses out on any market gains that occurred during the delay. Conversely, if the market crashes, Jordan is forced to pay out $400,000 from a diminished pot, effectively losing more than his 50% share. The step-by-step fix is to ensure the QDRO explicitly states that the award includes pro rata gains and losses from the date of valuation to the date of distribution. This ensures that both parties share the market risk and reward during the administrative limbo state. Step 3 is the fee allocation protocol. In the complex corporate landscape of 2026, 401k plan administrators have become increasingly aggressive about charging fees for processing QDROs. These fees can range from $500 to $3,000 per account. In an urban divorce where there may be multiple legacy 401ks from different employers, these fees add up. Historical trends show that if the decree is silent on who pays, the plan administrator will often deduct the fee directly from the recipient's share. Jordan's checklist must specify whether these fees are split 50-50, paid entirely by the participant, or paid by the alternate payee. It seems like a small detail, but in a 2026 masterclass on financial defense, every basis point matters. Step 4 is the legislative shield. We are currently operating in a period of rapid tax law evolution. With the full implementation of various retirement acts, the rules for when you must take money out and how it is taxed are in flux. A bulletproof 401k settlement in 2026 includes an anti-obsolescence clause. This clause stipulates that if federal tax law changes between the signing of the decree and the funding of the QDRO in a way that fundamentally alters the value of the distribution, the parties agree to return to mediation to adjust the offset. This protects Jordan from a midnight tax hike that could happen during the months his paperwork is sitting on a government desk. Now let us look at the post-QDRO audit. Even after the money is transferred, the process is not over. Step 1 of the audit is verifying the vesting status. We have seen case studies where a plan administrator accidentally transferred non-vested shares to an ex-spouse, only to claw them back 3 years later when the error was discovered during a corporate audit. Jordan must ensure he receives a final statement from the plan showing a zero balance liability to the ex-spouse and a confirmation that all transferred funds were fully vested. Step 2 is the beneficiary reset. As we discussed in the mortality section, the divorce decree does not automatically update your 401k beneficiary. You must manually log into your portal and file a new designation. In 2026, many urban professionals are utilizing the per-stirpes designation to ensure that if they pass away, their 401k assets flow directly to their children, rather than being caught in the probate of a second marriage. The historical trends of the last 40 years have shown us that the 401k is the most resilient, yet most misunderstood, asset in the American economy. It has survived market crashes, legislative overhauls, and the shift from pensions to personal responsibility. For the urban professional in 2026, successfully navigating a 401k divorce is the ultimate test of financial literacy. It requires you to be a historian of tax law, a forensic student of your own career, and a vigilant guardian of your digital data. You have now completed the 10-part deep dive into the world of urban retirement division. You have seen how the 401k became a weapon in the 80s, a tax bomb in the 90s, and an algorithmic battlefield in the 2020s. But while the 401k is the largest bucket of wealth for most Americans, it is not the only one. There is a secondary, even more secretive layer of the financial system that is currently being used to shield billions of dollars from the reach of the U.S. court system. It involves the intersection of executive deferred compensation, offshore shadow trusts, and the rise of private equity holdings that never appear on a standard W-2. In our next series, we are going to peel back the layers on the executive shadow economy. You will learn the specific mechanisms of the Top Hat plan, the hidden risks of the restricted stock unit, and why the most successful urbanites in 2026 are moving their wealth into assets that a QDRO can't touch. The 401k was just the beginning. The real game is played in the shadows of the C-suite. If you thought the 401k hunt was intense, wait until you see the data on the assets that were designed to stay invisible. The masterclass is evolving, and the next level of financial sovereignty is just around the corner.